The Senate Committee on Health, Education, Labor, and Pensions will please come to order. It's been nearly 100 years since the core of our nation's labor laws were passed. Since then, the economy and the way we work has changed. Congress should update labor laws for businesses, unions, and workers to make our nation competitive in this 21st century economy. President Trump deserves a lot of credit. He is committed to delivering the most pro-business, pro-worker administration in history. In pursuit of this, he's built a strong coalition of businesses, unions, and workers united to increase prosperity for all. As Help Chair, this committee should deliver on President Trump's pro-worker, pro-business, pro-family agenda. By the way, let's get some perspective here. In the last 10 years, we've had 4 different administrations, 2 Republicans and 2 Democrats. Now, when I speak to businesses in Louisiana and elsewhere, they feel whipsawed by changing administration. Everybody loves it when their team's in charge, and then their team is not in charge, and then they hate it. What we learn is that no one is in charge forever. I think that gives us the responsibility and indeed the opportunity to pass something upon which all can agree, in which we can bring stability to businesses, unions, and workers. Now, to do this, we have to build consensus on lasting changes that benefit all. My colleagues' continued engagement is essential. And my purpose in these hearings is to come out with actionable legislation that can pass on the floor, which means it can get 60 votes. Bringing certainty to all involved so that somebody planning their business, planning their worker activities 15 years from now will have some sense of where the guardrails are, which I think that sense has been lost. Earlier this month, the committee heard from a wide range of voices on how to improve labor laws to protect workers' rights and expand freedoms. First, we must strengthen workers' voice in deciding how their hard-earned dollars are spent, especially when it comes to funding political activities that do not benefit workers. Workers should not be forced to fund ideologies and entities that violate their beliefs. Congress must protect workers' rights in the workplace and on the picket line, defending workers from harassment and abuse and empowering them to protect their personal data. We should curb frivolous, unfair labor practice charges that worsen the NLRB's backlog and delay workers from asserting their rights in the workplace. Another serious issue is the impact of illegal immigration on the workforce, taking jobs and driving down wages for hard-working Americans. The Trump administration has made this a priority. It is something the committee will examine closely. Finally, Congress must restore worker choice in the unionization process. This includes considering ways to enhance the integrity of union elections, helping workers reach that first contract in a timely manner, ensuring they can determine when their labor contract is working for them. These are key principles that will guide this conversation and hopefully our future legislative action. By reforming our labor laws, we will deliver on President Trump's pro-worker legacy and empower the middle class to achieve the American dream. And with that, I recognize Senator Sanders.
Thank you, Mr. Chairman. I did not realize that we had the most pro-worker president in the history of this country. Did not know that, Jesus. Imagine that, just arbitrarily throwing tens of thousands of federal workers out on the street, breaking union contracts in an unprecedented way, neutering the National Labor Relations Board so that they cannot deal with labor issues that come before them. Did not know that that was on top of taking away health care from 15 million low-income and working-class Americans, raising premiums for 20-plus million Americans by doubling what they're going to have to pay for health insurance. I did not realize that was a pro-worker agenda. God help us if we had a president who had an anti-worker agenda. But Mr. President, what we're talking about today is a very important issue. And the question I think we have got to, and other committees have got to address, is a simple fact. We're living in the wealthiest country in the history of the world. And over the last 50-plus years, we have seen an explosion in technology and worker productivity. Everybody recognizes that. And with artificial intelligence or robotics, we're going to see even more of a transformation of our economy. So the question, it seems to me, Mr. Chairman, that we have to ask ourselves is, in the wealthiest country in the history of the world, how are working people doing? How have they done over the last 50 years? Well, interestingly enough, in terms of inflation accounted for real wages, over the last 52 years, the average American worker has seen a decline in real wages. Really? Increased worker productivity at a decline in real wages. Where has all the income and wealth gone? Well, during that same period, according to Rand Corporation, there has been a $75 trillion transfer of wealth from the bottom 90% to the top 1%. So today we have the insane situation where one man in America, Mr. Musk, owns more wealth than the bottom 52% of American households. Top 1% owns more wealth than the bottom 93%. All over this country, working class families struggling to put food on the table, struggling to pay for childcare. They can't afford housing. They can't afford the basic necessities of life. We talk about good food, wanting to make sure our kids are not eating junk food, dealing with obesity. How many working class families can afford good quality food for their kids? Richest people never had it so good. Working class struggling to put food on the table. Now, how does that happen? Well, a number of reasons. Certainly it happens because of disastrous trade policies, which have shut down factories all over America, decimated communities. But it also has to do with an attack on trade unions in this country. And Mr. Chairman, in your presentation, you forgot to mention one reality, and that is millions and millions of workers today want to join unions, but they're unable to do so because of the illegal behavior of corporations, who now can act with impunity because we don't have an NLRB. So workers want to join a union, companies fire the union organizers, they threaten their workers to move the jobs to China, et cetera, and nothing happens to those employers. So if we want to grow the middle class in this country, maybe we should allow workers in this country to enjoy their constitutional right to form a union. Now, today we're going to hear from two great union leaders, Mr. Arnold and Ms. Turner. And they're going to talk to us what's happening in St. Louis, Missouri right now. The struggle, the decent people who are manufacturing some of the best airplanes in the world, skilled workers, demanding decent wages, decent benefits from Boeing, while their CEOs make zillions of dollars. These guys are starting off at wages which are really disgraceful. They've gone on for a long period of time trying to get a union. They haven't. And in terms of Ms. Turner, we're going to hear from nurses who, by the way, are the backbone of our healthcare system. Ms. Turner, let me thank you and all the nurses in our country for the extraordinary work that they are doing, and they're struggling for decent working conditions, decent wages, in order to take care of their patients. So let me thank all of the panelists for being with us. Mr. Chairman, thank you very much.
I will now go to our witnesses and introduce each as they are to testify. First is Mr. Thomas Beck, Senior Advisor at the Littler Mendelson Workplace Policy Institute. He previously worked as Vice President for Labor and Employee Relations at HCA Healthcare, where he gained on-the-ground experience with contract negotiations and labor law. He chaired the Federal Labor Relations Authority under President Bush and was renominated as member by President Obama. He is a graduate of the University of Virginia and the UVA School of Law. Thank you, sir, for being here.
Chairman Cassidy, Ranking Member Sanders, and members of the committee, thank you for the opportunity to offer a few observations about labor management relations and labor law. The remarks I share today are not those of any organization with which I am or was affiliated. Rather, they are my own, based on 30 years as a labor lawyer, labor regulator, and labor relations practitioner. I want to note that there was a time when I wouldn't have thought labor policy to be such a current topic. 34 years ago, when I walked into the first day of my labor law class at the University of Virginia, our professor, Stan Henderson, greeted students by saying, "Welcome to the study of a dying area of law." To borrow from Mark Twain, the death of labor law was greatly exaggerated. The pandemic, with the concerns that it brought about job security, workplace safety, and worker voice, gave new opportunities to organize labor. And the political realignment that allowed President Trump to gain a second term by winning the popular vote in every one of 7 swing states suggests that maybe, just maybe, there is some basis for finding bipartisan consensus to benefit the American worker. First, labor law should bolster the sanctity of the secret ballot. Most importantly, it protects employees against coercion or retaliation from any direction. If the secret ballot is appropriate for electing a United States senator or for a Senate conference to elect its leaders, I don't know why it would be inappropriate for employees to select their exclusive representative in the workplace. Compared to the alternative of card check, the secret ballot facilitates a more informed choice about union yes or union no. In the card check scenario, employees get the union's perspective, which is, no surprise, pro-union. But they're not given an alternative perspective. For example, they hear little and maybe nothing about union dues or about the important reality that a labor union cannot guarantee outcomes in collective bargaining. In contrast, with a secret ballot election, there's a greater likelihood of an actual campaign taking place with competing viewpoints offered to employees. And again, less chance of social pressure or outright coercion affecting a voter's personal decision. And if we really want workers to be able to express their preferences on unionization, we need to deal with tactics that nullify the votes cast by those workers. These are called blocking charges, unfair labor practice charges filed by unions seeking to delay or stop an election, especially a decertification election, that they anticipate will not result in their preferred outcome. Historically, fewer than half the unfair labor practice charges filed with the NLRB are found to have merit. In most years, it's in the range of 35 to 40%. If we want to effectuate worker choice, we should not delay elections for charges that statistically are more likely than not to be meritless. And because they are blocking charges, are even more likely to be frivolous. Indeed, the very concept of a blocking charge rests on a shaky assumption, in my view, which is that an employer can so effectively threaten or coerce an employee that it affects how the employee votes in a secret ballot election. But by definition, the secret ballot means no one but the employee herself knows how she will vote or how she did vote. As a consequence, it's difficult to see how threats can be effective or retaliation can occur. No, the strong presumption should be that once an election is scheduled, it will take place as scheduled and its result implemented. In the very rare circumstance where it's established that some misconduct or irregularity had a material impact on the outcome of a secret ballot election, the election could be rerun. And finally, we should put an end to the unnecessary battle between Section 7 of the National Labor Relations Act and Title 7 of the Civil Rights Act. If we care about American workers, we should want them to enjoy Title VII's protections against a racially or sexually hostile workplace. But in some cases, the protections set forth in Section 7 of the NLRA have been so stretched and so misapplied that they've eviscerated the protections of Title VII. For example, in one recent case, an administrative law judge of the NLRB determined that Section 7 insulated from discipline a male employee who referred to a female employee, quoting now, as a gutter bitch, crack hoe, and queen of the slums. When it enacted Section 7 of the NLRA, the 74th Congress encouraged workers, quote, to engage in concerted activities for the purpose of collective bargaining or other mutual aid or protection. Given the language it used, I doubt that Congress of 90 years ago intended to encourage hateful, racially, or sexually offensive behavior. Again, thank you for allowing me to appear today, and I look forward to answering any questions that you may have.
Thank you, sir. And next, we're going to hear from Vincent Vernuccio, president and co-founder of the Institute for the American Worker. His work focuses on the impacts of labor policy on American workers, has been featured in the Wall Street Journal, New York Times, National Review, and Forbes. He previously served as special assistant to the Assistant Secretary for Administration and Management in the Department of Labor. He is a graduate of the Ave Maria School of Law, and we thank you for being here, sir.
Chairman Cassidy, Ranking Member Sanders, and members of the committee. My name is Vincent Vernuccio, and I am president of Institute for the American Worker. I4AW is a 501c3 educational organization focused on empowering American workers, job creators, and entrepreneurs. Thank you for giving me the opportunity to testify here today. The problem with today's labor law is that it stems from the 1930s, and it is based in the Industrial Revolution workplace. Its outdated prescriptions are for a different economy, and they do not address the individuality and the flexibility that today's workers want. The following suggestions empower workers to work how they want, with whom they want, and in a way that is best for them and their families, creating modern labor policy for a modern workforce. Many of these can be found in Senator Scott's Employee Rights Act, which is a compendium of the best pro-worker labor ideas in Congress, as well as several other bills that have been already introduced here in the Senate or in the House of Representatives. First, workers should have the ability to work for themselves without government mandates putting them in a box. Senator Scott's Employee Rights Act and Modern Worker Empowerment Act provide a better test for who is an employee versus who is a freelancer or an independent contractor. Additionally, Chairman Cassidy's Unlocking Benefits for Independent Workers Act and Senator Paul's Association Healthcare Plans Act would further health and retirement security of independent contractors, allowing them to get benefits from their clients without the fear of being categorized as an employee, or simply band together to get more competitive health care. When it comes to unionization, workers should have a say on their representation, or if they want to be under a union's collective bargaining agreement. The Employee Rights Act and the Workers' Choice Act allow unionized workers in right-to-work states to opt out of a union contract and represent themselves. Additionally, it would free unions from having to represent people not paying them, something which I know that members of this committee have expressed concerns about in the past. Workers' choice allows workers to say no thanks to unwanted representation and unions to say goodbye to workers not paying them. It is truly an idea that can address all sides of the labor debate and could be a showcase of bipartisan reform. Next, for workers that are unionized, every worker should have a say on who represents them. Currently, almost 95% of unionized workers have never had the opportunity to vote on the union at their workplace. Representative Onder's Worker Enfranchisement Act would require a quorum of workers to vote before a union is given exclusive representation to represent all employees in a unit. It would also protect workers' right to a secret ballot, similar to the Employee Rights Act, making sure that employees can vote in private in unionization elections, eliminating potential coercion and intimidation that comes from so-called card check organizing, where workers can be organized by open petition without the protection of a private vote. Once workers select a union, they should have the easy ability to remove the current union at their workplace, select a new one, or go without a union. Changes should be made to address the contract bar, which limits when employees can petition, change, or remove their union. During an election, worker privacy needs to be protected. The Employee Rights Act puts employees in control of what personal information is given to unions. Additionally, workers deserve to know if they are speaking to someone who is being paid to influence their decision on unionization. Representative Owens' Start Applying Labor Transparency, or SALT Act, ensures that workers know if they are speaking to a union organizer posing as an employee. The SALT Act requires so-called union salts to file the same reporting requirements as consultants that management hires to talk to employees. Workers deserve to know if they are talking to someone that is paid to persuade them on unionization, whether it is management or a union. Finally, workers deserve to be protected from harassing and discriminatory language in the workplace, no matter the scenario. Another provision in the Employee Rights Act closes a loophole created by the National Labor Relations Board, which allows harassing and discriminatory language that could even violate Title VII of the Civil Rights Act to be used during union activity. Again, I applaud the committee on looking for pro-worker solutions to address the needs of today's workforce and entrepreneurs. I would be happy to take any questions. Thank you.
Thank you, sir. And then we're joined today by John Hartley, a current PhD candidate at Stanford University and a graduate student worker. He'll provide insight into the difficulty workers have in opting out of subsidizing union political spending with which they disagree. Mr. Hartley is a current policy fellow at the Hoover Institution and previously served on Congress's Joint Economic Committee. He is a graduate of the University of Chicago and holds degrees from the Wharton School of Business at Penn and the Harvard Kennedy School. I look forward to hearing from you today, and you'll get the award for being the most overeducated. So anyway, please, Mr. Hartley.
Thank you, Chairman Cassidy, Ranking Member Sanders, members of the committee. Thank you for the opportunity for being able to speak today. My name is John Hartley. I'm an economist and currently an economics PhD candidate at Stanford University. The purpose of my testimony today is to use my story to highlight a major challenge in American labor law, the coercive use of union membership, dues, and fees for political purposes unrelated to workers' economic welfare. Many in the American public today may not be aware that in recent years, many groups of university graduate students have formed unions. This includes Harvard, Cornell, MIT, and Stanford, where I currently work as a teaching assistant. Let it be said that I firmly believe that workers have the right to organize, and this is an important pro-worker right to allow for workers to engage in collective bargaining for improved wages, benefits, and working conditions. However, many unions today have expanded beyond traditional workplace bargaining into broader political activism, which can alienate members who disagree with these causes. The student unions often are led by some of the most progressive students on their respective campuses. Many of these students have affiliated with the United Electrical Workers, one of the most progressive unions in America. It was the first national union to endorse the BDS campaign against Israel in 2015. It supports many additional progressive causes, including abortion, Medicare for all, the Green New Deal, abolishing ICE, and the No Kings protests, which protest President Donald Trump. I first entered Stanford as a graduate student in 2021, with no idea that a graduate student union would be formed in the years to come, nor that it would become a condition of employment as a worker. In 2023, the Stanford Graduate Workers Union was certified and affiliated with the United Electrical Workers. In November of 2024, to avert a looming strike, leadership at Stanford signed a collective bargaining agreement that included a forced dues clause, making joining the United Electrical Workers or paying it fees a condition of employment at the university as teaching assistants or research assistants. Earlier this year, the Progressive Union obtained my email and phone number and sent many harassing texts and emails threatening to terminate my employment at the university if I didn't join or pay money. Eventually, they sent a termination request to the university in June of this year. In August of this year, I was told by university officials that if I did not pay the union by the end of the week, my employment at the university would be terminated. California is not a right-to-work state, and hence workers like me who object to funding a progressive union have limited options. Technically, graduate students have the right under the Supreme Court's 1988 Beck decision to opt out of full union membership and dues payment and pay only agency fees. However, these fees are nearly identical to regular dues and still end up in union coffers of a union that makes progressive politics a primary part of its mission. I would contend that this is not sufficient to protect workers. Another path exists for religious objectors under Title VII of the Civil Rights Act. The challenge here is that what constitutes genuine religious accommodations often left up to the union, though the law clearly states that a university has discretion as well to determine such an accommodation. Because many of the issues the union supports contravene my Catholic faith, I refuse to pay money to an organization that supports causes contrary to my moral and religious principles. By the National Charter of the United Electrical Workers, the majority, at least 2/3 of union dues collected by the local affiliates of the United Electrical Workers go to the national body, whose agenda exists far beyond the typical concerns like wages, benefits, and working conditions. I requested such a Title VII religious exemption from union payments. Typically, people who are granted such an exemption after filling out an exhaustive survey about their religious practices are still required to contribute funds to one of a set of non-political charities provided by the union. My exemption was actually just granted over the past week, 2 months after I requested it, and I have to choose amongst the American Cancer Society, the American Heart Association, and the Nature Conservancy to pay the equivalent amount of union dues each year, which is in the amount of roughly $600 to $800 per year. The United Electrical Workers spend this money on political causes. Now, what might be the consequences of forced contributions to progressive political causes as a condition of employment? Will this discourage conservatives like me from applying to graduate schools going forward and becoming professors? Labor law reform should consider the political dimensions of unions. Why not bar them from political activity? If I felt that my contributions were not being used for political purposes, but instead focused on wages and benefits and improving worker conditions, I would feel better about making contributions. Why not treat them like 501c3s, which are barred from coordination with political parties and making direct financial contributions to them, part of me says this might be a step in the right direction, though perhaps not enough. Unions promote political causes in ways that go beyond official support for political parties and candidates. I mean, it could also run aground of free speech protection for unions in Citizens United. Another path might be national right-to-work laws that would stop unions from forcing workers to pay dues or fees to labor unions. Such laws would let individuals decide for themselves whether a union deserved their financial support and would make it harder for unions to promote across-the-board progressive politics, since they would risk losing financial support from people who disagree. 26 or so states currently have right-to-work laws, and Yanis established national right to work for public sector employees. Respecting moral conscience should be primary in our labor laws if they're to be truly pro-worker. Unions should be focused on bargaining for their members to obtain better wages, benefits, and working conditions, rather than across-the-board progressive politics. Thank you.
Thank you. And I ask Senator Sanders to introduce the Democratic witnesses.
Thank you, Mr. Chairman. I'd like to introduce Joshua Arnold, shop steward for Machinists Union Local 837B at Boeing in St. Louis. Mr. Arnold is a worker on the FA-18 Service Life Modification Program at Boeing, where he has worked for 11 years. He is also a U.S. Army Iraq War veteran with 24 months of deployment, including a year in Iraq. Mr. Arnold, thanks very much for being with us this morning.
Chair Cassidy and Ranking Member Sanders and members of the committee, thank you for your opportunity to testify today. My name is Joshua Arnold. I was born and raised in St. Louis, Missouri. I'm a husband and father of two. I work as a support coordinator on the FA-18 SLIM program at Boeing St. Louis, where I have worked for 11 years. Like many of my coworkers, I began building my skills as a proud member of the Armed Services. I, along with 3,200 IAM Union Local 837 members working at Boeing in Missouri and Illinois, have dedicated our lives to manufacturing world-class military aircraft. For generations, IAM Union members in our shops have built military equipment that directly ensure U.S. service members have the tools needed to complete their missions safely and effectively. Together, we produce aircraft such as the F-15 Eagle, F-18 Super Hornet, and MQ-25 Stingray. Recently, our employer was awarded a multi-billion-dollar contract to produce the next generation of U.S. air dominance, the F-47 fighter. Together, we will proudly build this new aircraft, helping ensure U.S. national security and global aerospace leadership. For more than 50 years, our shop has been a union-represented workplace. That's half a century of this workforce negotiating a collective bargaining agreement, or CBA, with the company that spells out our wages and benefits and workplace policies. Our contract with Boeing expires every several years, and we have the right and responsibility to negotiate a new CBA which respects the skill and dedication of this workforce. I also serve as a shop steward for Local 837B, where I help ensure all members receive the benefits spelled out in our CBA. Unfortunately, in our 2025 negotiations, Boeing has been unwilling to negotiate a contract which respects our skill and dedication. Despite immense profits, inflated executive compensation packages, and golden parachutes in excess of $60 million, Boeing has been unwilling to put a suitable offer on the table. In the face of consistently increasing household costs, Boeing's offer would cause our families to lose ground. Some in our shop are already working second jobs to make ends meet. Boeing's offer is far lower than the offer recently extended to their workers in Washington State. Granted, these are good jobs, but my coworkers and I are far from getting rich. At the very least, we should not be losing ground. We are not shooting for the moon, but we believe we deserve more. Compared to our average salary of just $36 an hour, Boeing's CEO is paid nearly 300 times what we're making. We're also seeking improved employer contributions to our 401k. Several years ago, Boeing took away our defined benefit pension plan. In light of that, we are simply asking for a 401k match that is equal to the offer extended to their workers in Washington State, which is a drop in the bucket compared to the $60 million golden parachute some Boeing executives have received. In the face of Boeing's substandard offer, we, the workers, voted overwhelmingly to reject it. We urged the company to improve their offer. They declined. There are very few tools available to workers to coax corporations into doing the right thing. So on August 4th, we implemented one of the only tools we have. We voted to withhold our labor and strike until the company proposes an improved offer that respects our value. Boeing has made it clear that they put greed for skyrocketing profits over the people that actually earned them the profits in the first place. We are now in the 12th week of our strike. Despite our efforts, Boeing has not improved their offer one bit. In fact, they have backtracked and made it worse. We have now voted on and overwhelmingly rejected their offer 3 times. Still, company management refuses to negotiate in good faith and improve their offer. The wage and retirement improvements we are seeking could cost Boeing only half of the cost of one F-15 fighter jet over the next 4 years. We have now missed 6 paychecks. The company has cut off our health insurance and halted our retirement contributions. The decision to strike is a hard one, and holding the line this long is even harder. This strike has negatively impacted all of our members' families. Personally, my family and I have had to try to make ends meet on my wife's salary alone. We are more fortunate than many. We still have one income, but many do not have that luxury. We face the threat of foreclosure, eviction, unpaid bills piling up, and living without health insurance. Few families can afford to pay $2,500 per month to continue health care coverage through COBRA. Like many states, Missouri has no provisions to provide unemployment benefits or affordable health care to striking workers. Financial stress is a reality for all of our families. If that wasn't bad enough, we have been forced to endure ultimatums from the company like take this offer or else. Boeing continuously threatens to permanently replace us with non-union workers and move our work out of state. We are proud of our work, and we are concerned about the programs we work on and the timeliness of their deliveries. It takes more than 6 months of training to certify a worker on these aircraft, and it takes a lot longer to become a trusted journeyman capable of completing the complex processes involved in manufacturing military-grade aircraft. We are concerned about quality and safety if this replacement workers are brought in. The chips are undoubtedly stacked against workers in favor of corporations. We took this action because it is the tool we have, and we truly believe the company's offer does not respect our skill and dedication. We stand ready to negotiate an improved offer which respects our value. I again thank you all for the opportunity to testify today and look forward to answering any of your questions. Thank you.
Thank you very much, Mr. Arnold. Let me take this opportunity now to introduce Mary Turner. She is a registered nurse and president of the National Nurses United. President Turner still works weekend night shifts at the intensive care unit at North Memorial Medical Center in Robbinsdale, Minnesota. In 2022, as the president of the Minnesota Nurses Association, President Turner led the largest private sector nurses strike in American history, securing historic pay increases for 15,000 nurses across Minnesota. President Turner, thanks very much for your work, and thanks for being with us today.
Good morning. Can you hear me?
Yeah.
Okay. Good morning, Chairman Cassidy, Ranking Member Sanders, and members of the committee. Thank you for giving me the opportunity to testify here today. As Senator Sanders said, my name is Mary Turner. I'm president of National Nurses United, which represents 225,000 registered nurses across the nation. But more importantly, I always say I am still a bedside care nurse, an ICU nurse, night shift. Just got off the night shift this past weekend. So I've been in healthcare since I was a 12-year-old candy striper. I've been a nurse for 30 years, and I've been a union nurse for 29 of those years. And what has taught me through those 29 years is that a nurse needs to have a voice at the table. And the best way to get a voice at the table is to have a union voice at the table, because a union voice for a nurse means you have a contract with the hospital that compels them through a shared contract to be able to discuss patient concerns and patient issues. Because folks, that's what nurses really do care about. The benefits, the pay, that's all great. But our purpose in life is to care for our patients the best that we can. And what happens when we don't have optimal conditions? Let's get our staffing, okay? Hospitals just love to cut to the bottom line, cut staffing. Well, you know what ends up happening? You have fewer nurses, you have more patients, and then that means longer wait times for pain meds, increased risk of falls, infections, and sometimes, unfortunately, death. One would say, oh, there's a nursing shortage. I beg to differ. I beg to differ. It's not a nursing shortage. It is a shortage of nurses. It is nurses leaving the bedsides in droves because they cannot tolerate the working conditions. Workplace violence alone, in a 2024 survey, 8 out of 10 nurses experience workplace violence at work. Little story here. Back in a decade ago, a mental health nurse came into a nurse meeting. I said, well, how's your day? And she goes, well, I wasn't hit. I said, what? Well, yeah, that's how I gauge my day. If I had a good shift or bad shift, whether I was hit or not. Okay, let's fast forward to just a couple months ago. Spoke to a young nurse. We were discussing the fact that a pregnant nurse had just got kicked in the stomach. And she says to me, she goes, I tell you what, Mary, I'm going back to school because I am not going to be at the bedside. She was in her mid-20s. I am not going to be at the bedside when I start wanting to bear children. This is why they're leaving. The short staffing, the workplace violence, they are leaving the bedside because our nurses are highly educated and they can do a lot of other things than to have horrible working conditions and unsafe working conditions. But that's also why nurses across the nation want to unionize. And, well, like the HCA hospitals in Florida, and also we have our nurses down in New Orleans at the University Medical Center who are trying to form a union, trying to get a contract. And what do they run up against? They run up against their hospitals trying to interfere with their, oh, now I'm losing my words. Well, trying to interfere with their ability to form a union and get a contract, okay? And you have to understand, a union contract for a nurse means they have the right to advocate for their patients, okay? It's safety in the workplace, safety for our patients is our top concern. So that's why we're asking for stronger labor laws. We're asking to protect our right to organize. Because when nurses have safe working conditions and a safe place to work and enough staffing, that means it benefits our patients. Now, I'd like to touch a little bit on the whole fact that Medicaid and Medicare is being cut. People won't stop coming to the hospital, okay? You know what's gonna happen? All those people without medical, you said 15 million, they're going to come into the hospital because somebody will find them collapsed somewhere on the sidewalk or in their home. They will bring them into the emergency room and they will go right, instead of having preventive care, they'll go right to my ICU at some of the most expensive care that you can get. A few years ago, on my ward, just the bed alone was $8,000 to $10,000 a day. So you're gonna come in and now we're gonna pay for the most expensive care. So the things I would ask, first, we need to end this government shutdown. We have to put the federal workers back to work. And secondly, we need to finally pass the PRO Act to give everybody the right to freely join a union. Because I'll tell you what, for nurses, when we have a voice, that means our patients win. Thank you. Oh, sorry for going over.
No problem, Ms. Turner, and thank you for seeing patients. I mean, just as a physician, I just want to really thank you for being frontline. And ICU on the weekend shift is not what everybody signs up for. So thank you for that. I shall begin. I have a bunch of questions. I'm going to ask you to keep your answers tight. Mr. Hartley, did the union justify to you why it was pursuing political goals unrelated to wages and working conditions, which I think you listed, BDS, Medicare for All, Green New Deal, No Kings, et cetera? Did they ever justify that?
No, not particularly, but you can find these on the National United Electrical Workers website. The Stanford Graduate Workers Union website also puts information on forthcoming protests, for example, regarding the situation in the Holy Land, but not particularly when it came to actually.
I always ask people to think on the other side. What if a union was requiring people to be on the opposite side of those issues? Would the other graduate students feel that unfair? And I think this is the time for that. Mr. Vernuccio, you talk about the tension that Section 7 of NLRB prevented employers from taking actions against harassing, abusive speech. You also mentioned this as well, Mr. Beck. Where should the line be drawn between speech protected by NLRB and the harassment prohibited under Title VII of the Civil Rights Act?
Thank you, Mr. Chairman. Workers deserve to be protected, and their employers deserve the ability to make sure they are protected from vile, harassing, and discriminatory language. The Trump administration, in their General Motors case before the National Labor Relations Board, established what's known as the right line test. This said, as long as the General Counsel of the NLRB does not establish that there is Section 7 animus, or the employer is simply going after the employee because they are unionization, that because they're trying to unionize, that those employers should have the ability to protect decorum and respect in the workplace and discipline employees that are violating Title VII of their coworkers.
Yeah, I agree with that. I mean, the coarseness of that exchange of the quotes I think that you gave, Mr. Beck, frankly, should not, a fellow worker should not be subjected to. I think the Trump administration got it right there. Mr. Arnold, I'm told that the striking workers that you worked with had voted down 2 tentative agreements between IAM and Boeing, one of which IAM called a landmark contract. Now, we heard in our last hearing about the role of arbitration as a potential solution to a first contract. But as I understand, arbitration could take workers out of the process by removing the need to ratify a contract. Put differently, if the leadership came up with a contract, arbitration said, yep, this is it, then the members could not reject it. As you mentioned, they've already rejected 2 things that have been offered. What would happen if the IAM workers lost that ability to ratify a contract?
Thank you for your question, Senator. It is my understanding that in our Constitution, our members get to vote on the contract, period.
If you go to arbitration, my understanding is that if you have arbitration and it's an agreed upon, then that becomes the contract, at which point the workers would not have the ability to reject.
If that's the case, then that would be removing the democracy from the workplace, which is the whole point of a union, giving the worker a say.
Sounds good. Yeah, well, thank you for that answer. Mr. Beck, under its non-acquiescence doctrine, NLRB does not consider circuit court precedent when issuing its decisions. And the NLRB argues that it ignores precedent in order to preserve the national uniformity of federal labor laws, but then violates that uniformity by oscillating back and forth between policies based upon which party controls the board. And it's my thesis that this every 4-year oscillation we've had over the last decade has really been bad for unions, bad for business, bad for the worker, bad for our prosperity. Now, what do you think? I mean, am I overstating this, or do you feel like this kind of whipsawing is negative and that we should somehow balance it out?
I think that you're onto something there, Chairman Cassidy, both with the non-acquiescence and with what we sometimes refer to as the policy pendulum at the NLRB. With the non-acquiescence to circuit court rulings, the NLRB has not created uniformity. What results is a patchwork where we have the Third Circuit says one thing and the Fourth says a different, the Fifth says a different. What I think the solution to, we can't change the fact that different circuit courts will occasionally come to different conclusions, but at least we could provide certainty to the employers within those circuits by insisting that the NLRB follow the law of the circuit in where the employer is located. In terms of the policy oscillation, this whipsaws everybody, unions, employees, and employers, and there are some classic examples from recent years. The one that occurs most obviously to me is how elections are conducted. And the Obama NLRB introduced what some called quickie elections and others of us called ambush elections. And then the first Trump administration board went back to sort of the more standard way to run elections on a more historical timetable. And then we had the Biden board come back and change the election rule again. So this kind of policy oscillation leaves everyone wondering, my gosh, how can I plan and how do I really know how to conduct my labor relations? Because the NLRB may issue a different ruling or a different rule a year from now or 2 years from now. They've done the same thing in a way that affects the entire American workplace, not just those that are unionized, with the way the board has handled facially neutral workplace policies over the last 2 or 3 administrations. One,
I'm going to ask you to wrap that up. Hang that.
I'll just say that there's been oscillation about employment policies as well.
Sounds good. Senator Sanders.
Thank you, Mr. Chairman. I was interested in hearing concerns among some of our panelists about union roles in election. I didn't hear too much about the reality that one man, Mr. Musk, was able to spend $270 million to help elect Donald Trump president, and that billionaires are buying elections every day. Mr. Arnold, you and your coworkers, as I understand it, have been on strike for 80 days now. And as I hear it from you, Boeing has not come to the table with a serious offer. What does it say? How do your workers, your fellow workers, feel when Boeing could afford to pay its CEO, Mr. Ortberg, more than $18 million in compensation for just 4 months of work, as I understand it. $18 million for 4 months, but apparently they just don't have enough money to sit down with the union and negotiate a fair contract. What does that say to the workers at Boeing?
Thank you for your question, Senator Sanders. Well, it tells us that they don't value us. It tells us that they're seeking to maximize shareholder value by limiting inputs like wages for laborers. That's us. So we produce the value, but we don't get any piece of that value, or as little of a piece as they can allow to get by with.
Now, as I understand, you guys are producing some of the most sophisticated airplanes in the world, fighter planes in the world. Is that correct?
That's correct, Senator.
You got some really skilled workers doing enormously important work, right?
That's correct, Senator. And not only that, a lot of our members have to maintain security clearances, which is no small feat in and of itself.
All right, what has been the impact of this strike on workers at the plant?
Thank you again for your question, Senator. The impact on the workers on the plant is that they've had to go for 6 paychecks without any income. They've sought alternative jobs. Their health care has been cut off, so they've had to seek.
Say that again. I mean, you guys had decent health care under the previous contract, and Boeing did what?
They cut our health care off, sir. And when they cut our health care off, we had to find alternative means. So those who have spouses that work maybe were able to get on their spouse's care, but a lot of them had to pay $2,500 a month to get COBRA coverage, which is not very affordable when you're receiving $300 a week in strike dues or strike pay.
Okay, thank you very much, Mr. Arnold, for what you're doing. Ms. Turner, I have met, as the former chair and ranking member of this committee, met with nurses all over the country, literally from coast to coast. And what has impressed me is that nurses have come into my office with tears streaming down their eyes. And you know what they were in the office? So not to say we need more money. Yeah, they wanted better wages. They were there because they said, I'll never forget this. We were trained to do our jobs. We can't do our jobs. We don't have the staffing to do our jobs. It breaks our heart that we can't provide the quality service. Our people are suffering, patients suffering, sometimes dying. And we want help so that we can do our work. And I know that's a point you made. Am I missing something in that is the feeling of many nurses throughout this country?
Senator Sanders, you're absolutely right, that it is heartbreaking. We get, and it's not called burnout, okay? It's called moral distress. When nurses go home, and I feel especially for our young nurses who come out, and they come out with all these grandiose plans to be able to take care of their patients the best that they can, and then because of short staffing, workplace violence, just horrible working conditions, schedules that are not manageable, and they come away, especially when they have too many patients, they come away, they leave their day, they go into their parking lot crying their eyes out because they feel defeated. Okay, they feel like this is not what I signed up for. I wanted to make a difference in my patient's life, and I don't feel like I'm doing that. And just add that to the many reasons why nurses are leaving the bedside. Once again, we do not have a shortage. We are not treating our nurses right, and we need to start treating them right because they are the backbone of healthcare.
Ms. Turner, I know that the National Nurses United agrees with my position that healthcare is a human right.
Definitely.
That we need a Medicare for all single-payer system. My guess is that in your years of experience, you've encountered many patients who walked into the door who should have gotten health care months and months before. What do you think it will mean to this country when 15 million people are thrown off the health care they have because of Trump's massive cuts to Medicaid? What will that mean to health care in this country?
Senator Sanders, what that will mean, and I alluded to it in my opening statement, no preventive care, no managing their chronic diseases, and so what ends up happening is these people, how often has my story that I take from the emergency room said, patient found down, patient found collapsed in their home or whatever. Then they call 911, they bring them into the emergency room, and what do these do? Because they're in such poor shape, all body systems collapsing, they go to the ICU. Like I said, most expensive care. That's what's going to happen. They're not going to stop coming to the hospital, and furthermore, it's going to be uncompensated care.
Thank you very much.
Senator Hawley.
Thank you very much, Mr. Chairman. Thanks for calling this hearing. Thanks to all the witnesses for being here. Mr. Arnold, if I could just start with you. It's good to see you. I want to start by thanking you for your service to our nation. I think you're an Army veteran, is that correct?
That's correct, Senator.
Did 24 months deployment combat tour in Iraq. Thank you for your service to this country, and thank you for your continuing service to the country. Now you're dedicating your life and your skills to building the most advanced and capable military aircraft in the world. Let's just talk a little bit, though, about the company that is currently not giving you, your fellow machinists, what they deserve. You've been on strike now for, it's about 12 weeks?
That's correct, Senator.
And in this 12 weeks, the Boeing Corporation has cut off your wages, of course, cut off your medical care. You were saying to Senator Sanders a moment ago, and I just want to make sure that I understand this and that everybody else hears it too. You don't have any medical care right now, so what's that mean? I mean, how are you going to be, if somebody gets sick, you got a kid who's sick, what do you have to do?
Thank you for your question, Senator. That means you're going to have to pay out the wazoo. If you have to go to the hospital or if you have to give any sort of medical care, God forbid you have an injury or hurt yourself, doing your normal routine or fall down some stairs, you're going to be up the creek without a paddle, as they say.
You have to go and get, if you want to have any kind of insurance, you got to go and get COBRA, right? And you said that costs what?
$2,500 a month, Senator.
$2,500 a month. Now, what is it that you're getting? You're getting nothing in salary. What is it that you're getting in support from the union and from the local? I mean, what are your workers able to get?
The strike pay right now, if you work one strike shift, you get $300 a week. I work 12 hours once a week as a strike captain, and then that gets me $300 for the week.
$300 a week, and just to buy medical care, basic care for your family is $2,500 a month, and that's before you got to make rent. I assume you got to buy groceries, you got to buy gas. This is really unbelievable. It's just unbelievable to me. Just tell us and tell everybody who's listening to this what it is you're asking for, because if you listen to these Boeing executives, and believe me, I've heard from them. All the machinists are so unreasonable. It's all unreasonable. My answer to that is we got 3,000 plus Missourians who have been loyal to this company for years. You've been with the company over a decade, if I remember correctly.
That's correct, Senator.
So, to me, it's incredible for these people in the C-suite who make unbelievable sums of money and who, by the way, have strip-mined this company for parts. I mean, you talk about what they have done to Boeing, this proud American company, and we're very proud of it in Missouri. I mean, our contribution to Boeing is second to none. This is a company whose planes have literally been falling out of the sky in pieces in recent years. Why is that? I think we all know why. It's because they won't commit to safety standards. They won't pay their workers well, but they pay their CEO and their C-suite more than ever before. I think the last guy got paid $38.5 million in a single year when they were testing the safety of their doors with cheesecloth and Dawn dish soap, if my memory serves. So just tell the nation here today what it is that you're asking for.
Thank you for your question, Senator. We're asking for a halt to the pay freezes. We had an 8-year contract from 2014 till 2022 where we had pay freezes for the top of scale. And if you're not getting a pay increase, you are getting a pay cut in your real buying power. And then we had a 3-year reprieve in the last contract with no pay freezes. And then this new offer, every offer that they've given us had 2 years of pay freezes. In addition, they took away our pension plan in the 2014 contract. And since they're taking that away, we would like to have an improvement to our 401k plan so that we have an opportunity to potentially have a retirement with dignity. And all we're asking for is the same plan they offered to our members in Washington State, which is a 100% match. Additionally, the bonus that was offered, the signing bonus that was offered to Washington State and North Carolina was $12,000. They offered us $5,000, and they said if you don't take this offer, you will never see $5,000 again. To work in a company, when I started in 2014, it was $11 an hour that they started people out at. And I had to work my way up, working multiple jobs, until I got enough raises per the union contract to be able to only work one job. And when you're doing that and working on multi-million-dollar aircraft, there's a little bit of a cognitive dissonance that happens there.
Sounds like to me what you're asking for is pay that keeps up with inflation, allows you to keep your head above water, do something for your family. You're asking for a decent retirement. You mentioned the machinist who struck in Seattle. They got a 38% general wage increase over 4 years, a $12,000 one-time ratification bonus, or a $7,000 bonus plus a $5,000 401k contribution. I'm delighted for them, and that sounds like a good contract. Are they offering you anything like that?
No, Senator.
Yeah, I'll just end with this, Mr. Chairman. I know that my time has expired. I want to say thank you, Mr. Arnold, and I hope that you'll take the message back to everyone who's out there striking, that we stand with them. I want to see you get the contract that you deserve. And I also want to say, for those of us who consider ourselves to be pro-family, you can't be pro-family if you can't make a wage you can support a family on. We've got to be able in this country to have good-paying jobs where people like you and those other 3,000 Missourians can earn a wage where they can support a family. That's what pro-family policy looks like, and I thank you for fighting for that. Thank you, Mr. Chairman.
Thank you, Senator Hawley, and now Senator Hassan.
Well, thank you, Chair Cassidy and Ranking Member Sanders, for holding today's hearing. Thanks to all of our witnesses for being here today. Before I get to my questions, I do want to take a moment to address the fact that we are still in a federal government shutdown. This shutdown is now in its 4th week, and I remain focused on finding a bipartisan solution to reopen the government and prevent a healthcare calamity. With due respect to my colleagues, a pro-worker president does not stand idly by while working people's health insurance premiums at least double. That is not what a pro-worker president does. In my state of New Hampshire, if we do not extend the ACA, the healthcare.gov premium tax credits, a family, a couple, 60-year-old couple earning $85,000 a year is going to see their premiums go up by at least $14,000. And that, of course, to Senator Hawley's recent point just now, is not sustainable. So, Ms. Turner, I want to start with a question to you. I've been a longtime supporter of the Protecting the Right to Organize Act, the PRO Act, which would strengthen collective bargaining and organizing rights for workers. What provisions of the PRO Act are top priorities for your members?
Well, first of all, it gives us the ability to freely organize without union busting tactics.
Right.
Okay?
Yeah.
And then secondly, the bill gives like real consequences to employers that violate labor law and try to detour us with union busting campaigns. And it most importantly, it protects our nurses who are trying to unionize from being terminated or fired or harassment, because that's what's going on with our nurses that are trying to unionize. And so overall, like I said before, and I'll say it again, a union helps nurses to advocate for the patients at the bedside, get us better working conditions. And so this PRO Act is everything to the nurses. Yeah. Because I'm fortunate in Minnesota, 85% of our acute care hospitals are unionized.
Yeah.
But I'm worried about the whole rest of the world.
Right.
The whole rest of the nation needs to have that same privilege that we have in Minnesota.
Yeah. And the difference in an ICU bed when you only have 1 or 2 patients versus multiple patients is extraordinary.
And the fact that in other states, they have 3 and 4 in their ICU.
Yeah. Another question for you about health insurance premiums. They're set to double for many families next year. I'm really concerned, as you just heard in my remarks, about how these increases will harm families, but particularly how they will harm our healthcare workers and our patients. You've talked in your testimony about the impact of having more uncompensated care, more people without insurance on your patients' health. Can you talk about how nurses and their families will be impacted if their health insurance costs skyrocket next year? Because what we know is as more people become uninsured and as other premiums go up, even if you don't get your coverage on the marketplace, on the ACA marketplace, health insurance premiums are going up. So can you talk about the impact on nurses and their families?
Well, here's the thing is that, and I'm going to come from the hospital standpoint.
Yeah.
Okay? Uncompensated care means the bills aren't going to get paid.
Right.
That means they're going to start closing units, cutting services, closing. We're already seeing where rural hospitals are going to close, but I want to bring something to your attention. In Minnesota, we have 5 level 1 traumas. We have Duluth, Rochester, North Memorial, my hospital, HCA, and Regents anyway, 5 of them, okay? And we service a 6-state area.
Right.
Okay, everywhere from Michigan to the Dakotas, they all come to our level 1 traumas. We do a lot of Medicaid and Medicare, okay? These other hospitals that do just ortho and babies,
Yeah.
they're not going to take on the level 1 trauma. Just imagine a world without our level 1 traumas.
Thank you for that. I don't want to imagine that world, but it may be coming our way. Mr. Arnold, workers in the manufacturing industry face one of the highest workplace injury rates of any profession. What are some of the top health and safety concerns that you're bringing to the bargaining table, and what priority protections in this area are you fighting for?
Thank you for your question, Senator. Right now, we're mainly focused on economic issues. We have a high-performance work organization that we have established with the company for years, where departments will elect a team lead, and that lead will lead initiatives that from the workers, from the ground up, they will make their suggestions into team-based improvements. And that could be anything from developing a more ergonomic tool to do a job, to changing the order in which work is done so that it makes it easier to assemble a panel without a wiring harness in the way. It could be anything along those lines. And that is a partnership between the union and the company. The company wants to eliminate that organization. They have asked the union to voluntarily give it up, even though it's in our contract. And I believe they are still asking for us to do that. Our members would like to keep that, not only because there is also a stipend, a 50 cent an hour, $40 pay period, a stipend for being a team lead.
Thank you. Thank you, Mr. Chair.
Senator Moody.
Thank you, Chairman Cassidy, and thank you to all our witnesses for being here today, many of which have been following Florida's effort to support workers and been involved with that in detail, and I'm excited to talk to you today. It is a great thing that we are spending so much time in this committee focusing on American labor. I think this is remarkable. I commend our chairman and the ranking member for bringing these issues to the forefront of this committee, the Senate, and the attention of the American people. I think it is so important that we address how we can do better by the American worker. It's unfortunate that we have to meet under these circumstances, under the shadow of a Democrat-forced shutdown, and you're going to hear time and time again that they're working for a bipartisan solution. It's been a yes or no vote to keep the government open, a bipartisan funding bill to continue current spending. That's what it's been. We've just voted for the 11th time, and they voted no. Some of the Democrats still have their sanity, have voted yes to support this country and keep it open. It's now the longest shutdown, full shutdown in American history. And so I just want to make sure that the record is clear. You can vote yes and keep this open. Some of your Democrat colleagues agree we should do that. That's our job here in Congress, and I would urge you to do that. It seems appropriate when we're having a hearing on American workers that we note that the American workers and the people here, they have never shut down or given up on this nation. And through the president's leadership and leadership in our Senate, we will ensure that we are focused on the American worker and how we can do better in the policies that we are passing here in the United States Congress. In Florida, we have citrus growers, cattle ranchers, service providers, independent contractors, and proud union members. We have a diverse workforce, and everything I do here in Washington will recognize that, and I want to make sure that we are empowering and supporting all Florida workers. In fact, the ultimate goal of unions has always been to empower, give workers an equal voice, support them, and anything that is done that would prevent that mission, I would think the union members wouldn't want that. Union leadership wouldn't want that. And so I thought it was really interesting in Florida, when I was in leadership, we passed legislation that empowered public sector employees, and it prohibited automatic mandatory paycheck deductions for union dues and allowed workers to revoke membership if they decided it wasn't working for them anymore. Seems to be pretty common sense. I don't know why anybody would be against that. But the Biden administration didn't like that. And when they learned of that, they threatened millions, hundreds of millions of dollars in funding to the state of Florida because they didn't like that law. And it was an example of how they were using, the administration was more focused on its political allies and political arrangements and political support than it was to focusing on what we can do to empower and support all American workers, regardless of their employment arrangements. And I think one of the things this administration has done well, and certainly I think we should focus on, is going back to what is the mission? What are we trying to achieve? Why were some of these organizations started? And go back to, are we fulfilling the aims of those policies? And if we're not, let's discuss what we need to do differently. That's why this committee has been on it. I've been here, I'm the newest senator here, and I have loved watching some of the issues we're embracing with vigor and real dialogue and a deliberative way to say, are we achieving the ends that we sought out to seek? And if we're not, let's do something different. I wanted to turn my questions to you, Mr. Vernuccio. You know I know you know fully well that in Florida, as Attorney General, I had to bring suit against the Biden administration when they threatened our funding of $800 million because we passed legislation. I want to hear from you, if you can tell us more about your thoughts on that Florida law and how you think parts of that law might provide a mechanism for us to do things here in the United States Senate as we're adjusting our policies.
Well, thank you, Senator, and thank you for your leadership on this issue, both as Attorney General in Florida and currently as Senator. And thank you, Chairman Cassidy, for your leadership on this issue. I know you wrote letters to then Acting Secretary Julie Su to protect the workers of Florida. We heard from one of my fellow panelists about union democracy and how having arbitration to settle contracts is undemocratic. The Florida bill, SB 256, promoted union democracy. It said that when union membership in the public sector drops below a certain threshold, that workers should have the right to vote, that public employees should have the right to vote. And unfortunately, the Biden administration, through Acting Secretary Julie Su, tried to stifle that for transit employees. So your question to what can the Senate do? I know in the House, there's the Worker Enfranchisement Act that would require a quorum before a union can be certified to have a monopoly and represent all workers. That is one example of how protecting union democracy, making sure that workers, the majority of workers, have a say on who represents them, especially when they are given a monopoly. So once again, thank you for your leadership.
Thank you.
Chairman.
Senator Alsobrooks.
Thank you so much, Mr. Chair. We are now here today in day 22 of this government shutdown, but are proceeding with business as usual, still discussing abstract labor policy while dedicated public servants all across our country and in my state are going without a paycheck. It has been 22 days of this administration refusing to come to the table in good faith and negotiate a plan to keep the government open and make sure that health care is affordable and accessible for millions of Americans. It's been 22 days of this administration using the shutdown as an excuse to further target federal workers who are my constituents. Just last week, the very sinister Russell Vought ominously tweeted, "The rifts have begun," before illegally terminating thousands of federal employees. This is a man who has outwardly taken pleasure. He said it was his greatest intention and desire to traumatize federal workers, said he wanted them to be regarded as villains, and he is harming federal workers. Hours later, President Trump and Secretary Kennedy fired more than 1,700 people from the Department of Health and Human Services, including staffers that work to prevent measles outbreaks, before admitting that they had sent nearly half of the notices to employees in error at the CDC. Imagine that. With a family to support, you get a notice that you were fired before getting another email hours later telling you, oops, that RIF has been rescinded. The chaos and cruelty of this administration is unconscionable, and I am telling everyone who will listen, it will scar our country for decades to come. President Trump fired 465 more employees at the Department of Education, including the Office of Special Education and Rehabilitative Services and the Office for Civil Rights, putting our most vulnerable children and their rights in the classroom at risk. At the Department of Housing and Urban Development, the administration fired the entire team of building inspectors responsible for making sure that around 5 million homes are safe to live in. And just yesterday, the Interior Department revealed plans to fire more than 2,000 additional staffers. And I want to point out that one of our witnesses here today has claimed that federal workers are oppressing their members. The federal worker unions are oppressing their members, stopping them from, quote, making their own decisions about what's best for them in response to the president's illegal attempts to force federal staff out of their jobs that they love, and jobs in service to the American people. Public service unions are the only organizations standing in the way of these illegal mass firings, the outright political targeting of civil servants, and cruel efforts to traumatize dedicated and critical federal employees. Because of their efforts, a federal judge, who I might note has temporarily blocked these ridiculous and illegal firings, acknowledged that they were illegal in excess of authority and arbitrary and capricious. Again, at its core, we are in this situation because this administration is refusing to work with us on a simple fix to prevent health care costs from increasing for millions in just 10 days when open enrollment opens. And I'm glad that we have Mary Turner here today from National Nurses United, a union that has experience with the effects of policies designed to make health care less affordable and accessible for Americans, and one that has specific experience with the impacts of this administration's attacks on federal workers. NNU represents nurses at the Department of Veterans Affairs, which has revealed plans to lay off up to 80,000 employees this year. Cuts like these and cuts to the Affordable Care Act will have direct implications on patient care. So I don't have any questions for our witnesses today because our job is not to debate the merits of these workers in a hearing room. It is to show federal workers their value by protecting them from illegal attacks and getting them back to work. So I hope that all of my colleagues will also join me in this effort. Thank you, and I yield back the time.
Senator Baldwin.
Thank you, Mr. Chairman. I, too, want to start by addressing the fact that we are now in day 22 of a government shutdown because Republicans won't extend the enhanced tax, premium tax credit that ensures that tens of millions of families can afford their health care coverage. We just heard from a member of the majority blaming Democrats, who represents a state that has the highest reliance on the Affordable Care Act. There are 4.7 million Floridians who rely on the Affordable Care Act marketplace for their health insurance, most of whom also rely on the tax credits to be able to afford it. We are on the brink of seeing the largest increase in health care premium and costs in history. And that's what this fight is about. And so I do have questions of the panel beyond wanting to address that fact, because, Mr. Arnold, you have talked about the impact of the withholding of health care coverage on the workers who are on strike, which is, the last option, but a significant one when you're trying to collectively bargain for fair wages, fair benefits. So in pursuit of protecting Americans' access to quality and affordable health care, I have a bill called the Striking and Locked Out Workers Health Care Protection Act. It would create a separate unfair labor practice category for when employers cut or alter workers' health insurance while they are locked out or on strike. I want to ask you, as I asked a witness in our previous hearing on labor law reform, can you talk about how this bill would help workers fighting for fair contracts if it were in place right now.
Thank you for your question, Senator. I think if that were in place right now, that would address the $2,500 a month COBRA fees that our members have to pay. And to put that in context, the difference between where the company is and where the union is half the cost of one F-15 fighter jet. Over the course of that 4 years, we are going to produce those at a rate of about 2 a month. That's 96 F-15s. We are going to blow our shoulders out drilling on titanium for 4 years to make 96 F-15s, not to mention some number of F-18s, some number of MQs, some number of T-7As, some number of small diameter bombs, JDAMs, harpoons, surface launch systems, and flight simulators for all those programs. And we're saying we're going to deliver that, all of that to you. We want a fraction of 1% of one of the programs. And that's what they said, cut your health care. Get back to work.
President Turner, thank you for being here today. You spoke in your opening comments significantly about the violence that nurses face in the workplace. I was incredibly disappointed to see the Department of Labor under this administration downgrade the workplace violence and health care and social assistance rule so that it's no longer a priority in the rulemaking process. Essentially, it's sitting in rulemaking purgatory. That's why it's really critical that we pass my bill, the Workplace Violence Prevention for Healthcare and Social Services Act, which would compel OSHA to create an enforceable standard to create the safe workplaces that your colleagues deserve. President Turner, would you be able to give us an understanding of what kind of workplace violence your nurses are experiencing and what types of improvements will likely happen in hospitals if we pass this bill to force OSHA to create enforceable standards?
Thank you, Senator Baldwin. First of all, I want to thank you from the bottom of my heart for this legislation. Walked in their ED not too long ago because we can fill out a concern for staffing if, nurses can fill that out if they're having staffing issues. And I was compelled to go down to the ED because in 1 week, 4 nurses had been beat up. 4 young nurses, and they were out of work. Oftentimes, these workplace injuries end their career. We've had broken heads, broken arms, broken hands, okay? And every time that happens, that's another nurse that loses the ability to do what we are called to do, take care of patients. This is, we had in 2015, I was the leadership behind the very first workplace violence legislation in Minnesota because we got on national news in 2014 in St. John's because of a horrendous, it was all across the news, look it up. Anyway, that next legislative session, we passed the first workplace violence legislation. And now, but we can't just have it just in Minnesota, okay? Mm-hmm. And the thing is a big part of the workplace that your legislation is addressing the staffing. Yeah. Oh, I'm sorry, does that mean quit? Okay, all right, sorry. Oh, you're so kind about it, okay. But anyway, long and short, staffing, workplace violence, those are 2 big issues, and I thank you.
Ms. Turner, because you're a nurse, I gave you 20 extra seconds. I've resisted commenting on some of the almost invective regarding the current shutdown, but I will point out that premiums are going up no matter if we paper over the premium increases on the exchanges with this $26 billion in subsidies. And the subsidies are required because the Affordable Care Act has become the Unaffordable Care Act. And premiums are going up 20% in the employer-sponsored insurance, which has nothing to do with what we're currently battling over. They're going up 30% in the Obamacare exchanges, but only a small portion of that is related to these exchanges. Now, Republicans, if Chuck Schumer agreed to open today, we would be negotiating today. How do we actually lower health care cost, which is better than papering over? And I wasn't going to bring this up, but we've had a series of conversations about this, and I think it's important to set the record straight. Senator Hickenlooper.
Well, I don't want to interrupt that dialogue. I certainly look at the budgetary issues that came out of one big beautiful bill, or we call it the big ugly bill on our side. It really has created massive budget holes in Medicaid and SNAP, forcing states like Colorado to make really difficult, almost impossible decisions in balancing their budget. The shutdown has only made it worse, and I think as states are forced to make up for Trump's cuts in key programs, states across the country are wrestling with the same issue that Colorado is. These are impossible decisions impacting real families as they try to balance their budgets after the drop-off, the dramatic drop-off at various levels from the federal government. So in Colorado, the states had to make a sequence of very difficult cuts around Medicaid dental care, affordable housing programs, higher education funding, public health services. They're almost impossible to make because of all at every level, these cuts in federal funding to states. So, President Turner, as you know, there is a crisis going on right now, a healthcare crisis unfolding across the country. In the next several days, millions of Americans will receive notices in the mail that their premiums aren't just going up 15 or 20%, but going up, in many cases, 50%, 100%, as in advance of the open enrollment that starts on November 1st. This is on top of the millions of Americans that will lose their access to Medicaid because of the cuts that came across from the big beautiful bill. President Turner, in your testimony, you talk about the impacts of loss of access to care. What this is not just the impact on the patients, but also on the providers who care for them. Obviously, especially the nurses. Layoffs, unsafe staffing, service reductions. These are all exaggerated at rural hospitals. When you look at these cuts, what is the single thing that keeps you up at night? What's the part that you look at as what happens to nurses in rural areas if they're no longer able to care for patients?
Especially thank you, Senator, for that question, especially in rural America, all of these communities, oftentimes, whatever healthcare facility they have, be it a nursing home, a hospital, or a clinic, they're probably like the biggest employer of the town, okay? At least that's how it is in Minnesota. And so you start having all these hospitals close, or clinics, or whatever it might be, close because they can't afford to stay open, that has a ripple effect, an economic ripple effect, and it turns that town into a ghost town. Because I'm sorry, you take away the healthcare facility and the school, and a town dies. And we've all seen it. You got one grocery store and maybe one bar, and that's all that's left. Okay? So it's denying. And then let's just take the labor and delivery world. I dread to have been having children nowadays if I'm in rural America, and you're having to travel 50, 100 miles when you're in labor because the nearest place is the big town.
I hear you. Your point is well made.
Thank you.
Mr. Arnold, I'm a firm believer in diverse, cost-effective pathways to careers. We've millions of young people each year that are choosing not to go to a four-year college, that just growing. We need strong pathways for them. While I was governor, we started working on expanding quality youth apprenticeship programs. A lot of what we started in Colorado, I think we're in 22 states. In your testimony, you mentioned it takes a long time to become a trusted journeyman, capable of the complex work you do. You also honed your skills as a mechanic in the Army. Another example of earn while you learn model. From your perspective on the shop floor, could you speak to the value of apprenticeship programs for building the kind of highly skilled, robust workforce that our aerospace, defense industries, and so many others all depend on?
Thank you for your question, Senator. No amount of book learning can replace firsthand experience. I also have a four-year degree, but I also have done the like you say, the Earn While You Learn program as well. And you might learn something from the engineers about how this is supposed to go together, but then if you go talk to the aircraft mechanic who puts it together, he will tell you that the blueprints are correct and it needs to be to the blueprint. However, you got to do it a certain way. And that type of tribal knowledge you only get from firsthand experience doing the job yourself. Things work great on a computer in a 3D rendering, but when you actually have to crawl in there and get that wiring harness in that compartment, there's a certain way of going about it, and you only learn that from actually doing it. And we have members that go through our training program, and they are taught by the members on the line who are doing the job, who've been doing the job for years.
Great, thank you very much. I yield back to the chair, whose gavel I want to point out is poised.
It's still up, though. Mr. Arnold was doing a good job. Senator Markey.
Thank you, Mr. Chairman. Over the last 30 years, Boeing has transformed from a company known for safety excellence to a company with its safety record in shambles. At the same time, the company, which was once working in partnership with its unions, has turned hostile. Boeing resists wage increases, moves production to non-union facilities, makes it harder for union workers to raise safety concerns. Now Boeing refuses to agree to a fair contract with striking machinist workers in Missouri. It makes you wonder how Boeing can ever expect to restore its safety culture when it is working so hard to undermine its own workers. So, Mr. Arnold, do you agree that Boeing's union busting is a threat to aviation safety?
Thank you for your question, Senator. Absolutely, I think it is a threat to aviation safety.
Mr. Arnold, my safety starts at the top act would require Boeing's leaders to consider its workers and safety during every single business decision. My bill would require large aerospace manufacturers to have representation from their labor groups and aviation safety experts on their boards of directors. So I look forward to working with the machinists and my colleagues on this committee to advance this important legislation. Do you think stronger legislation is needed, Mr. Arnold?
Absolutely, Senator. I believe stronger legislation is needed. The firsthand experience of working on the shop floor, I know that our members are not afraid to speak up because they have the protection of a union behind them. They're not going to get beat over the head if they bring up a safety issue or a quality issue.
So thank you. President Turner, I want to ask you about training repayment agreement provisions, or so-called traps. Put simply, a trap is a coercive contract that says if a worker leaves their job before a given time period, they must pay the company for training, equipment, and even for lost profits. So you must stay or you must pay. So let me clearly state these contracts are largely illegal. They can function as illegal non-competes, depressing wages by limiting economic mobility. They scare workers out of exercising their rights under the National Labor Relations Act. They restrict competition with small businesses who cannot hire trapped workers. And when repayment exceeds the total wages that a worker earned, they are minimum wage violations. In some cases, workers find debt collectors banging down their doors for tens of thousands of dollars. Some workers are not even fully aware of these contract terms when they start a new job. They just sign here. You're the newbie. Sign up. Oh, you're signing away all your rights? Well, they're not lawyers. They don't have legal counsel. So these contracts are just so dangerous. Workers need the freedom to leave their job if a workplace is unsafe, if they are being sexually harassed, or if they need to take care of themselves or their family. So traps rob workers of that fundamental dignity. And nearly 1 in 12 workers today in America are subject to a trap. And the number is growing. That's the business plan. Yet the Trump administration has seemingly dropped all enforcement efforts to rein in this dangerous practice. Yet again, Trump is prioritizing corporate profits over American workers. So, President Turner, nurses are often subject to these contracts. Can you tell us what that means for your workers?
So the average nurse in Minnesota comes out of nursing school anywhere from $68,000 to $100,000. Okay, so they got their student loan already. And now we're talking about a system which I believe is kind of a modern-day indentured servitude kind of thing going on here, where they have to pay $10,000 to $30,000 to get trained in. Okay, when I started back in the hospital in 1996, I had my experienced nurses on the floor. I was on a neuro floor. They had about 150 years of experience, the 6 of them. That's who trained me in. This is an affront to our whole profession that is designed to have the experienced nurses teach the novice nurses. And we don't charge them $10,000 to $30,000 to do it.
So what's the danger of this? Where are we heading?
Well,
what are you most
like
afraid of?
like you had said, that so they're forced to stay there, and so then the working conditions, and if they dare to bring up the fact of a union, they're fired, and then they're still responsible for whatever they signed, right? And so it causes our nurses to just be afraid to fight for our patients, and that's a bad thing.
Thank you. Thank you so much for what you do. Thank you, Mr. Chairman.
Senator Kane.
Thank you, Mr. Chair. I want to thank the chairman and ranking member for having these 2 hearings about labor law issues. I think we've surfaced a lot of issues that are important. I'm a strongly pro-union, pro-PRO Act supporter. I'm a strong supporter of Senator Hawley's bill that would do the subset of the PRO Act that focuses upon getting from an election to a contract in a more reasonable time period. But I have learned something from the majority witnesses too, Mr. Hartley. I'm with you on the notion that if you're in a bargaining unit where there's been a collective bargaining, a decision by an election to have a bargaining unit, you should have to pay for being represented, but you shouldn't have to pay for political points of view that you don't agree with. And I don't know what the legal, answer to that is, but I would think unions saying we're not going to compel you to support political causes you don't agree with might find more people would be willing to vote for union representation. There actually could be a plus in there for unions that do that. So I appreciate you raising that issue. Many of us have commented, my colleagues have commented on why are we here in a shutdown, and I'm going to continue the dialogue. We're here for one reason. There is one ingredient that is missing today that we always have when we avoid a shutdown or when we need to get out of it, and that's presidential engagement. We've been close to deadlines many times, and when we avoid shutdown, it's because president engages. And when we're in a shutdown, as we last were when Donald Trump was president, 2018-19, we get out of it because the president engages. The president told the Republican majority in the House, write a budget deal without dealing with Democrats. That was his instruction. That's what they did. And they passed a partisan bill without dealing with Democrats, despite the fact knowing that there would need Democratic votes in the Senate. Senate Democrats did not sit on our hands when the president said they should not deal with us. We put an alternative on the table on the 18th of September, 12 days before the deadline. Not a non-negotiable demand, an alternative. Protect people's health care like you protected tax cuts for the wealthiest, and guarantee to us that a deal is a deal. If we shake hands on a deal, we'll follow, will you? We asked to meet with the president. The president scheduled a meeting, then canceled it. Then he agreed to have a meeting on September 29th, and as soon as the Democrats walked out of the office, he put up AI-generated videos of them wearing sombreros and talking in funny accents about things that they didn't say. We've elected a middle schooler to be president. It's ridiculous. And since then, he hasn't engaged. He had time last week to have a meeting in the Oval Office to promise $20 billion to the president of Argentina if that president's party succeeded in midterm elections. But he doesn't have time to meet with congressional leadership. He had time yesterday to have a lunch on the East Lawn of the White House to show the destruction of the East Wing of the White House to our Republican Senate colleagues, but he doesn't have time to sit down and meet with congressional leadership to get the government open. The Democrats renewed the request yesterday. The president's on the verge of traveling abroad to Asia. Before you go, let's sit down and work this out. The president this morning refused. We've never had a president so disengaged in the things that Americans expected him to lead on. He promised to bring down costs, health care going up, energy going up, building supplies going up, tariff idiocy affecting the economy. The GDP in Virginia grew by 6.2% last year and by 1.7% this year. 3 university reports have demonstrated it's because of Trump's economic idiocy. Mr. President, focus, for God's sake. Don't spend your time coming up with AI videos of leaders in sombreros. Don't spend your time coming up with videos of yourself as king, dumping excrement all over the American people. That might be the most honest thing you've done in terms of showing who you are and how you are governing this country. Have a meeting where we can sit down and find a path forward. And lastly, I'll just say this, Mr. Chair. Today's a day where Virginians are really seeing what the big, beautiful bill is. Now, I think that the title was chosen because bill means piece of legislation. But today's the day, starting last night, where 400,000 Virginians are receiving from the Virginia market information about what their health insurance premiums will be come open enrollment on November 1. And the light is dawning in their head. That's what the big bill is. The big bill is the massive increase in health care costs to my family. That's why they chose the topic, the big, beautiful bill. Now I see how much more I'm going to have to pay unless we can find a solution to do for everyday folks on their health care what we did for the rich with the tax breaks. I believe we can. I believe Republicans want to. I believe Republicans need to. They're seeing it in their states just like I'm seeing it in mine. If the president engages, we will solve this within a matter of hours. I yield back.
Thank you, Senator Kane. I'm here the whole time, so I get to ask questions twice. So, Mr. Hartley, your testimony points out that Stanford had the ability to override some of the demands of the union, and that when it came to Jewish students in the Northeast, they did that and exempted them from voting for contributing their dues to BDS efforts. Where was Stanford in all this? They just seemed kind of craven in this whole process. Did you ever hear from the administration there?
Thank you, Senator, for the question. Thank you, Mr. Chair, for the question. So, in terms of my interactions with Stanford, it's largely through university lawyers. They've made the determination that it's up to the union to process these religious accommodations. What happened at MIT and Cornell, and what made that a bit different was those student unions also are part of the United Electrical Workers. You know, the Jewish students there were seeking religious accommodations, and the union had decided to classify BDS anti-Israel concerns or objections.
As political. You mentioned that in your testimony.
Political, not religious, exactly.
Yeah, but why wouldn't Stanford step up and make the same sort of kind of stand?
So my understanding is that the United Electrical Workers is now processing such requests, and I think this kind of in part came after EEOC charges were filed in the Cornell and MIT cases.
So it took federal action in order to stimulate the university to do the right thing. That would be my interpretation.
In the MIT and Cornell case, where the university stepped in, correct. I'm not aware of such cases at Stanford so far. I think they have been. The union's been processing these. Again, it took 2 months for them to process this, and these things are being processed by the national union, not the local affiliates.
Now, it seems as if they still picked the charity to which you could give. If you had decided to give to Mr. Vernuccio's alma mater, Ave Maria, would that have been an acceptable, repository for your donation? I'm thinking not. I just go back to people should consider what happens when the shoe is on the other foot. So thank you for that. Mr. Beck, frivolous, unfair law practices have been filed to delay an election or to deter a party from further pursuing an election. I'm told 50% of these are dismissed. Would reforms to the unfair labor practice process, like requiring proof of allegations, address this? Because it seems to be a lot of the problem.
I think that's correct, Chairman Cassidy. There would be different ways to do it, but a couple of weeks ago you had some witnesses, particularly former General Counsel Abruzzo, who talked about backlogs at the NLRB I think there's a variety of reasons for backlogs at the NLRB, but there's no doubt that the majority of unfair labor practice charges are not found to be meritorious year after year after year.
So what could MLRB do to deter the filing of these frivolous lawsuits?
I think that putting some guidelines or some requirements for some sort of minimal amount of a proffer of evidence or an offer of proof. I used to do civil litigation, and when you file cases in federal court, you have Rule 11 that says if you sign the complaint, you have to have a basis in fact and law. And there are other rules that prevent the filing of frivolous claims or frivolous lawsuits. But before the NLRB, what Congress has done is it's created an agency where a labor union can say, hey, this employer has acted badly, now you go investigate it, and you go impose costs on the employers to make them respond. So the union just gets sort of handed off, and everybody else bears the burden and the expense. So what we could do is—
Does that invite retribution by the employer if the employee did that and put her name or his name? Ms. Turner has spoken about people complaining about bad working conditions. I assume they'd have to sign that. Would that become available to the employer to maybe potentially target?
Well, it could be. I think there are different ways to skin this cat, but one thing you might do is provide the offer proof to the NLRB, and maybe in the first instance, at least, it's not made available to the employer. But if an unfair labor practice charge is pursued, the employer will eventually find out through the trial process, the litigation process, who all the witnesses are and who the complaining parties were. But maybe up front, maybe we pull that up front so that the NLRB has some basis to determine, wow, is there really a there there? Is there really any substantiation?
Mr. Vernuccio, just to finish up, the current law requires employers to disclose workers' private information, home addresses, personal phone numbers to unions during representation campaigns, and workers cannot opt out. I'd be a little nervous about that, you know, my personal information being given away. Is this needed to effectively reach employees in the bargaining unit?
Absolutely not. Going back to my testimony of these laws were written in the 1930s. It is clearly, even the transparency laws were from the 50s and 60s when we're dealing with labor law. It is pre-social media, pre the internet. There are multiple other ways that unions can modernize and reach out to employees. They do not need to be given home addresses, cell phones, personal emails. Legislation like the Workers' Choice Act puts workers in the driver's seat saying you can have one piece of information that they choose, but they are not mandated by the National Labor Relations, or employers are not mandated by the National Labor Relations Board to give all of this personal information. Of course, if workers want the union to have all that personal information, they are free to provide it on their own prerogative.
Okay. I ask for unanimous consent to enter a letter into the record from the National Federation of Independent Businesses pertaining to the issues discussed at this committee's labor reform bill, and all the members currently here say aye. Aye. At the end of the hearing, for any senator wishing to ask additional questions, questions for the records are due 5 p.m. Wednesday, November the 5th. Thank you again for the witnesses for being here. The committee stands adjourned.